Good morning. I wanted to speak with you for a few minutes about a case that was reprinted in the January 23rd, 2009 edition of the New York Law Journal, which came out of the Kings County Surrogate's Court. Surrogate Johnson decided this case. It's the estate of Eleni Kariadis, who died in 2003. And Ms. Kariadis died with three children, two daughters, Maria and Stella, and one son, George. Under the will, the decedent left her house in trust so that her daughters could live in the house, and then at the death of the last of them to die, the house would be sold and the proceeds distributed to the son George, or if George was not alive, then to his children. She died in 2003. In 2004, the children come into court and say that this trust is uneconomical. And one of the daughters now wants to move to California, and they can't manage the property, etc. It's too much of a burden. And since George's children were remainder beneficiaries under the terms of this testamentary trust, a guardian ad litem was appointed. So the guardian ad litem, of course, is and usually an attorney that plays the role of protecting a minor's interests in a proceeding. So this is what happened. They filed a petition to terminate the trust. And generally, the court, as the court writes, in New York, a testamentary trust is an irrevocable expression of the testator's intent, which is to be respected by the court. Its duration may not be foreshortened by judicial fiat or by an act of interested parties. Except in limited circumstances, a testamentary trust is indestructible. However, in New York, EPTL, the Estates, Powers, and Trusts Law, Section 7-1.19, provides for a mechanism for revoking and terminating a testamentary trust. So what happened was the parties come into court before Judge Johnson. A stipulation, an agreement between all the parties was entered into about how the house was to be sold and the proceeds divided. And Surrogate Johnson agreed with this stipulation. The guardian ad litem explained why he felt this was necessary, because the back taxes weren't being paid, and the petition the trustee and the children presented to the court said that they could no longer manage the property and that it was simply uneconomical to continue the trust. So under 7-1.19, the judge says, okay, fine, let's terminate the trust. That was in July of 2007. And in that July 2007 decision, the judge said, okay, fine, settle a decree, meaning come back to me with the final papers that you would like me to sign so that the trust can be terminated. Well, guess what? They never did that. The parties waited for a year, more or less, came back into court now with an amended petition asking the judge for basically the same relief to terminate the trust and distribute the proceeds. Interestingly enough, the court writes that although labeled as an amended petition, the petitioner is in fact bringing a new petition. Why? Because they never followed up, on the prior decision of the court, and so this now is considered an abandonment of the case. Abandonment. When the children brought in this new petition, which they labeled an amended petition, the court said, no, it's not an amended petition, it's a new petition, and we want you to go downstairs and pay the clerk a new filing fee. Okay, they did that. They come back into court. Now, though, the judge says, no, you can't do that. And the reason is that because we now have a new petition And the statute, section 7-1.19, is very explicit as to the reasons why a trust can be terminated. You have not alleged those new reasons in your new petition. Under 7-1.19 of the Estates, Powers, and Trusts Law, the EPTL, EPTL 7-1.19 provides that the court may terminate a testamentary trust if it finds that, 1, the continuation of the trust is economically impracticable. 2, the express terms of the trust do not prohibit its early termination. And 3, that such termination would not defeat the specified purpose of the trust and would be in the best interests of the beneficiaries. In this case, the new petition does not allege that the trust is that continuation of the trust is uneconomical or in the best interests of the beneficiary. It stated some other reasons, but not the reasons that are required by the statute. And so the court holds this is not a valid basis to terminate a testamentary trust, even with the consent of all of the parties. So there you have that. They'll need to, I suppose, start all over again and file a correct petition. Serve all the parties, enter into an additional stipulation, a new guardian ad litem. They'll have to start back again at square one. And so there you have it. That's it for this morning. I hope you've gotten some value from the little video this morning, and I hope you have a great day.